Okay, are you James Watt? You're James Gwatney?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Right out of the gate, they waive the formal reading of the indictment. That's strategic. It speeds things up, but it also signals there's likely a plea deal in place. When defendants waive this, it usually means the negotiations already happened behind closed doors. Question for you. If you're facing a felony, are you taking the deal quickly or rolling the dice at trial?
Yes, Your Honor.
Mr. Gwatney, in clause number 25 DCCR 0736, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements, and that's from March 5th of 2025. And how do you plead to that charge?
I guess guilty.
Well, there's no I guess. Either you did it or didn't do it. So are you guilty or not guilty?
Guilty.
Are you entering your plea of guilty freely and voluntarily? Answer out loud, please.
Yes.
Did anybody force you to plead?
I guess guilty is not something judges accept. A plea must be clear, voluntary, and unequivocal. That hesitation. It matters. Judges are required to make sure there's no confusion, no coercion, no gray area. This is someone giving up their constitutional right to a trial. There's no I guess in constitutional law.
Guilty today?
No.
Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gwatney is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely.
This is the heavy part people underestimate. He's not just pleading guilty, he's waiving his right to appeal. That means once the judge follows the agreement, that's basically it. Case closed. And notice the immigration warning. Even if immigration isn't an issue here, courts must advise defendants because a guilty plea can trigger federal consequences. A plea isn't just about jail, it can reshape your entire future.
And voluntarily find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court.
2 years, and because this follows the agreement, the judge doesn't deviate. That's key in negotiated pleas. Judges typically either accept the deal as is or reject it entirely. There's no remixing the sentence. This is the moment the paperwork turns into reality. Transport, intake, time served calculations, just like that. It's official.
Certification that shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Can I ask you one question?
Sure.
Whenever I was brought back from Oklahoma, I had 6 months left on my 3-year sentence. They sentenced me to ISF until discharge. Why was this charge that is being brought up on me now not brought up on me while I was being incarcerated back in ISF for the last 6 months?
How would you think I would know that information? I have no idea. I have no idea. I
have gone over the time frame.
And here's the twist. After pleading guilty, he's questioning the timing of the charge, but procedurally, once you've entered a valid plea and waived appeal, those kinds of challenges are almost impossible to raise. Timing issues, indictment dates, filing delays, those are things you fight before the plea, not after. This is why understanding the deal beforehand is everything.
with him. From what he told me, the time frame that he was in ISF was after this case was filed.
Yeah,
Case has been indicted over 6 months.
yeah.
Yeah, and
I don't
he-
know. I don't know why that didn't happen, sir. I'm not sure if it was
The
something.
charges were supposedly filed in June of 24. And I was arrested in 25.
These charges are from March of 2025, sir. And you
25.
just pled guilty to that and it's done. You got your 2 years. You can go back with the bailiff, okay?
Okay.
I don't know the answers to those questions. Good morning. Are you Luther Sharp?
Yes, ma'am.
And Mr. Sharp was previously in court in cause number 25 DCCR 0916. Entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for a cap of 15 years in prison and a dismissal in clause number 25 DCCR 0917. I've received the pre-sentence report and have you both had an opportunity to review that report?
Yes, Your Honor, I have.
yeah.
Are there any additions or corrections to the pre-sentence report?
No, Your Honor, I would note for the court, we did receive a follow-up memorandum after the PSI was created. The probation department was able to get in touch with the complainant in this case, and they echoed their agreement with the 15 years.
Okay. I don't see that I have that, but have you had an opportunity to review that?
I don't think I got that. I would see it on an email.
From probation?
Yes, sir.
Luther Sharp. But it's stating that the family
That the
is.
victim of the
victim
shooting
is-
urged the full 15 years, Your Honor. They didn't
Okay.
agree with the deal.
All right, I also have received numerous letters that Mr. Vasquez has provided on behalf of Mr. Sharp, Mr. Nichols. Were you given a copy of those?
I was, Your Honor.
And then, in addition, there are jail incident reports. We've talked about those in the past, and I have any updated ones. Have y'all had an opportunity to review that as well?
I have, Your Honor.
Yes, Sean.
Okay, then, Mr. Vasquez, you may proceed.
Judge, it's just a typo on the first page under defendant's version. First sentence, first line. Then it says I got 2 bikes I got out of Louisiana. I'm sure the court could get that out of the context, but
Okay, they weren't trikes, they were bikes. I mean, there's such a thing. I think
Strikes.
they were trikes.
Excuse me.
I don't know what trikes are.
3-wheel bike.
Ah. Well, then I withdraw my
Thank you.
typo correction. I beg your pardon. I should have known Justin doesn't make any mistakes. Judge, I know the court said you have all the support letters. I would just urge the court to sentence Mr. Sharp to something less than the 15-year cap.
Do you have a copy of this? Can you print him one? Give me just a second. I'm reviewing that updated, the memo. I want to make sure I've read that since it has the, interested party victims statement. I'll give you a copy too, Mr. Vasquez.
Thank you.
All right, anything else, Mr. Vasquez?
There you are.
Mr. Nichols?
Your Honor, with his criminal history, urged the court to exercise the full 15 years under the agreement. Um, I, and that agreement, I think, reflects any consideration, and an effort to, I mean, he did admit to it, and that's why, okay, it's lower than it would be otherwise. With his criminal history, he was looking at habitual enhancement. He had not been off of parole, I think, for too very long, only the last few years. He was, last sentence expired in 2018. And by his own admission, he was doing cocaine, and caused a disturbance at the house when he was kicked out. So he shot the home, the resident of the home. I'm asking for the full 15 years.
Thank you, Mr. Nichols. Mr. Sharp, you're lucky you're not here on a murder over a bicycle tire.
Yes, ma'am.
I mean, you went over there with a gun, so it makes me feel like there was some amount of, I don't know if I want to use the word premeditation, but obviously some sense that
Now, this is a courtroom reality check. The judge is pointing out what could have happened. 2 shots fired, serious injuries. The difference between aggravated assault and murder can literally be inches or fate. And notice something else. The prosecution pushed for the full 15 years under the cap, and the victim's family supported it. When victims weigh in during sentencing, judges listen. Final question for you. Does prior criminal history make a maximum sentence inevitable, or should every case start fresh?
you were going to cause issues or use that gun to show up just over somebody who was fixing a bike or a bicycle tire. Your last sentence was for 20 years. You received a 30-year sentence back in the 90s. I mean, you've been in and out of prison since probably you were a young man. And the nature of this offense and what now this man has to live with based on the injuries that you caused. I mean, he was, when I say it's lucky it's not murder, it's not like you shot at him, you hit him twice. So to me, your intention was not just to stop him, but to unfortunately, I mean, this is just not the way to deal with an argument over a bicycle tire. Is not to shoot somebody.
He tried to throw me out of his house.
Well, it's his house. He has a right to throw you out of his house. If you go to somebody's house and you start causing issues, it doesn't matter what it is. It doesn't matter if he had your bicycle tire and he wouldn't give it back to you. If that's the case, you leave and you call the police, but you don't go to somebody's house, cause problems, they try to kick you out of their house, and then you shoot them.
Yes, ma'am.
Do you see how crazy that sounds when I say it out loud?
Yes, ma'am.
At this time, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 15 years in the Institutional Division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. And I'm not real sure why a felon in possession of a firearm case wasn't filed against you also, because obviously you are a convicted felon and shouldn't have had a firearm in the first place. But I'm required to read this to you. But so because of the judgment, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. Good luck to you, sir. You can go back with the bailiff, and it looks like I will, there's in that second case, I'll find a, sign that dismissal
Yes,
as
Your
soon
Honor.
as it comes through.
Thank you.
Thank you.
Thank you.